Number 47, Sam Ginsburg, appellant versus New York. Mr. Redfield.
Mr. Chief Justice, members of the court, this is an appeal from the judgment of the appellate term of the Supreme Court of the State of New York, which affirmed a conviction of the appellant for having violated Section 484H of the Penal Law of the State of New York. Since the highest court of the State of New York, the Court of Appeals, did not take this case for review, the appellate term is the court in which it was a final court in which a judgment could be had. And this judgment raises several important and novel questions. And the first one is whether on its face and in its operation is Section 484H of the Penal Law repugnant to the Constitution, the First Amendment and the 14th Amendment, because it acts as a restraint upon expression. The second question is the statute vague and overbroad by its terms and its standards, if it has meaningful standards? And third, is this publication, or the four publications involved, within the scope of the statute? In other words, was the act validly applied to this particular appellant? I should say at the outset, Your Honor,
whether it was within the scope of the statute, just that question isolated is a matter of state law, isn't it?
Well, I mean constitutionally. In other words, is this particular magazine, for example,
within the scope of the statute? That's a matter of state law, New York law.
Within the scope, but as applied, as the statute has been applied and construed with respect to this particular publication, can you condemn this appellant?
Well, does the Constitution permit you to do what the state did with respect to that publication, regardless of what the statute says? That's our question, isn't it?
Yes, that's it. I should say at the outset, Your Honors, that if this weren't a criminal conviction and I had a choice in the matter, I would have loved confining the issue solely to the first question, because I think the issue is ripe, and not only is it ripe, but I think it is imperative that a decision be reached on that point, even if the appellant can be victorious on any of the other points. I think Your Honors should at this time undertake the task of putting at rest this question, which has caused so many uncertainties and so much debate. And the question comes down to this: whether the power of the state may be exercised to punish a person who sells certain publications enumerated in the statute to persons based on the age of the reader or the purchaser. And I say, too, that that basic question, falls into two categories. The first, as a matter of principle, is it repugnant to the Constitution? And secondly, that by its operation in effect as a pragmatic question, does it intimidate the vendor and publisher of books to the point where it becomes censorship? In other words, the second question, to be clearer, is similar to the question that was raised and decided in Smith against California. Smith against California, you recall, was a purely practical decision because the court found that under the circumstances of the operation of the statute, intimidation resulted with its consequent censorship. Now the court below, meaning the appellate time, in writing for affirmance wrote nothing, and the Court of Appeals also stated nothing, but I suspect from the argument that went on that its determination came about because of the case of the book case against Broderick, which was decided about a year ago in the Court of Appeals of the State of New York, and which I brought to this court. The book case decision rested on a dictum in the Jacobellis case, and also rested on a dissenting language in People Against Bookcase, in which case a prior law had been rendered unconstitutional by the highest court of New York. So, at this point, I cannot give you the ultimate construction of the statute as rendered in this case, but can only refer you to what was said in book case against Broderick. My appellant, who received a suspended sentence, is not a flamboyant vendor, nor a self-seeking or assertive knight charging along in the rights of free speech. He's just a poor, simple, humble owner of a candy store or a stationery store or a newspaper, delicatessen and luncheonette sort of a place that is so common throughout this country. He has this little store which is size 7 by 30 feet in the little village of Belmore, Long Island, New York. And he works from morning to late at night with his wife to eke out an existence. And so much so that he had to shut the store for about 3 days during the pendency of the trial in this case. And as I said, he sells almost everything that type of store sells. And as part of it, he carries about 200 titles of magazines. He has no choice in these titles. They are sent to him automatically by the jobbers.
You mean the tie-in kinds of...
They're sort of tie-in.
And if he wants time...
Well, he doesn't write...
Those things,
yes.
He has to take all the rest?
He either has to take that or... let's put it...
is that all in the record?
That's in the record. But not as a tie-in, and that is not developed to that extent. But it is developed to the extent which we popularly know in the field, and that is that he doesn't order these magazines. They just come to him from the distributor. Now, the charge against him was that on October 18th, 1965, he sold 2 magazines, one called Mr. Annual, and the other is Sir, this thing. And if Your Honors recall, just a few months ago, as I can recall, you had this particular title before you in the case of Gent versus Arkansas, which I argued here.
What's the title?
Sir is the name of the magazine. It's not the same issue as involved in Gent, but it's a similar publication. It's the girly type of magazine. At an early date, we used to call them Police Gazette magazines. Now they're called girly. And then there was another charge against him, that on October 26th, in 1965, he sold a magazine called Man to Man and Escapade, two similar type magazines. And it should be observed, of course he sold them to this boy of 16 years of age. It should be observed that the charge here is only that these pictures contain nudes. And the magazines contain pictures that were nudes. And that these were harmful to minors. That's all the charge is. And I emphasize it because you will see in a few minutes that the judge made findings which extended beyond that charge.
Are you asking us to review the findings?
No, I'm not asking to review it, but you can only take on the findings upon which he was charged. Cole against Arkansas situation. He was only charged with a certain crime. He can only be found on that charge.
Well, specifically, are you complaining about the finding that the written material, apart from the photographs?
Yes, that's right.
And you say that
should be disregarded because I don't think it's part of the charge. At the time of the trial, the defendant challenged the constitutionality of the statute on its face, and he was overruled and was convicted. The appellate term, as I said before, affirmed, and the Court of Appeals refused to review.
Could you repeat why, Mr. Redfield, repeat why we shouldn't take into consideration the reading matter in the magazine as well as the pictures?
Because he wasn't charged with the reading matter. He was charged merely...
What was the charge?
The charge was that these magazines contain nude pictures. That's all. Yes. You'll find a charge on page 2 and 4 in the record. But I don't want to dwell on that too much, although I bring it to your attention. I think there are more important issues in this case. Yes, you use charges on page 2 to 4 of the record.
Well, of course, that's a very important issue. He was charged with one thing and convicted of
Yes, but I say it's subsidiary to my main contention in this case.
What do you mean you're waiving it?
No, I'm not waiving it. Since, as I said before, he was convicted of a crime, I can't waive it. I'd rely upon it as the last straw. The judge, after the trial, made the following findings: that the boy was 16 years of age, and that the defendant knew or had reason to know that he was under 17 years of age, and all the magazines in question contained pictures of nudes. And then he made the finding that the magazine Escapade and Mr. Annual contained verbal descriptions and narrative accounts of sexual excitement and sexual conduct. So you see, there alone, it goes beyond the charge.
Let me get this. This is at page 248, isn't it?
I'm reading from page 5. Yes, in the record he's on
well,
page 5.
I'm looking at the court's finding.
Yes.
In which he finds that people have proven beyond a reasonable doubt that Corey was 16, that the defendant knew or had reason to know that he was that, and that People's Exhibits 2, 3, 4, and 5, now those are the 4 magazines, are they?
Yes.
Contained pictures and photographs depicting female nudities as defined by the aforesaid section.
Yes.
And it's this last further.
Yes.
That People's Exhibit 5 and People's Exhibit 3 contained verbal descriptions and narrative accounts of sexual excitement and sexual
yes,
conduct.
That's
and that's what you say is beyond the charge.
Scope of the charge.
And that's the Cole, Arkansas point, isn't it?
Yes. But, as I say, I'm not pressing that as the ultimate decision in this
You're
case.
not pressing it.
No, I
I
mean...
don't quite understand.
I mean, my emphasis is here is for a
You
decision.
think something else is more important.
Yes, I do. I do think.
You want us to declare the statute unconstitutional.
Yes, sir.
That's what you want.
That's-
Even if you can win on the
On
whole
other-
Arkansas.
Right, sir.
Why do you do that, Mr. Redfield?
Well, I'm not trying to make it harder for.
The last time you were here, you tried that too.
Well, I try often enough, and sometimes I succeed and other times not.
You put great stress upon this man being a very poor man, a very small man, and so forth. I would think you'd be interested in winning your case any way you could win it for him.
And, I also place that emphasis, I should say, is because many people confuse this Ginsburg with another Ginsburg that was here before. And I think that distinction is very clear in this case.
What was the sentence in this case?
He got a suspended sentence. The judge thought so highly of him as a man in the community who was worthy of his indulgence, and he suspended the sentence.
For how long?
Didn't mention. He just said suspended sentence, and that was it.
He doesn't impose a sentence and then suspend it.
That's right.
Well, what was the sentence that he suspended?
He didn't impose any
Well, then you
sentence. He just said
misunderstood
suspended
my question.
sentence. It's very common practice in New York to state that.
Do you challenge that practice?
No,
That was successfully challenged here not long ago.
I remember that, but and I should it should be pointed out too that this statute is directed at those who sell the magazines for a monetary consideration. In other words, if it were given away, the person couldn't be guilty of the crime, but if he got money for it, it made a big difference. And the reason I emphasize this is so that you could see that there's something wrong with this statute right off, because if the purpose of the statute is to restrict the promiscuous circulation of this type of magazine to those under 17, they certainly haven't attained it even in the text, because it can be distributed to those who will not pay a monetary consideration. In other words, if one of Tom Sawyer's crowd came along and offered a bookseller an apple, that would be all right. But if he got 10 cents for it, he can go to jail for a year. Now, of course, we all would like to have the best of literature for children, and I would say also for adults. And perhaps if I were emperor, I would say there are certain 25 books that everybody may read, and that would be it. But since I'm not an emperor, and I do not care to tell anybody what they may read, I have serious doubt as to whether or not there was great wisdom in this law. And also point out the fact that several of the amicus in this case, as well as the Columbia Law Review, had found some solace in the recent Gall case, in which children's right to read should be considered and protected, because children wish to be free of the orthodoxy of adults. But and this relates too to the observation made earlier today that children do not have freedom of speech as much as adults, and therefore they're not protected by the Constitution. I seriously doubt if the basis for the protection of the Constitution rests on the freedom of choice of children. That is, at the assumption made by Mr. Justice Stewart that because adults have a greater freedom of choice, therefore the children have to be protected. Well, I'm not so sure that adults have that freer choice. My opinion People are great imitators. Adults are sheep like everybody else. And the tendency is to follow the leader. I think the gist of the First Amendment is not that there is a freedom of choice in the reader, as there is a freedom of expression in the speaker, or the writer, or the publisher. That's what we're protecting. There's nothing in the Constitution that speaks of the audience. It's good to turn in this argument to the beginnings of things. And I start with Roth. Roth.
Before you do that, I'm not sure I understand what you last said. You mean that the First Amendment does not protect anybody except the speaker?
Yes, sir.
And that you can make any sort of... Well, how do you fit that with your theory in this case? Then it would follow, wouldn't it, that you can assess the scope of the police power of the state without reference to the First Amendment insofar as the issue relates to who may buy these magazines, if they may be so called.
Well, I wasn't approving any such doctrine that
I'm not asking you what you're proving, I'm asking you what your understanding is. But you said that
the First Amendment
does not protect a right to hear, a right to read.
Right.
Did you say that?
I said that the First Amendment is directed to the rights of the speaker, not so much as to the right of the individual or the regulation of the receiver of the information.
Well, then where does that leave you in this case? Then the police power of the state can operate within reasonable limits, but without any special reference to the First Amendment. I'm trying to understand you.
Well, what my protection is here is the protection of the vendor, which is the same as the person who speaks.
What you're saying then is that the protected interest, your submission is that the Constitution protects not the child's right to read, but the vendor's right to sell and the author's derivative right to turn out this stuff.
Yes. Well,
and so you relinquish any argument based upon the right of children or of adults, for that matter, to read.
Right. Well, I meant it in this respect. I said that there were others who went further than I did in this case, the amicus and the Columbia Law Review, who say that the Gall case protects the right of the reader or the child in this case, but I wasn't pressing that issue. I, on the other hand, was protecting the right of the vendor or the expressor of any idea. So, I'd say this, that the burden of proof, as we know, of a restraint on speech is really a very heavy one, and the burden is that of the state who would restrain this right. But in anticipation, in other words, I could say, let's wait and hear from the state and see what they have to say on their side. But in anticipation of that, I would like to raise these questions. Where is this authority derived? The Constitution says there shall be no abridgment of speech. And in Roth, you said, well, so far as obscenity is concerned, there has been a history, although some have debated that history. With due respect to you, Justice Brennan. And so the question comes up, where in the Constitution can you justify a restraint based upon the age of the reader. And I, for myself, cannot find such authority.
That, I suppose, is based on the premise that minors of between 16 or 18 have less IQ than those above it.
Yes, so have others above that age. Yes.
So that really what they're talking about here, and all of this, I presume, is trying to protect people with low IQs.
Yes. And how are you going to determine those IQs to begin with? And how about those who are above the age? How about 50-year-olds who don't have the IQ? And how about those of 16 years who have the IQs? Who is going to determine that, and why should anybody be subjected to this? And especially...
Well, I presume if you can decide the right to read according to age, you can decide according to IQs, can you? Constitutionally?
Well, if that was so, I don't know what we'd do about it. I mean, I don't know how we could administer such a law, or better yet, how one could sell books or magazines under that type of a law.
I presume most everyone's known people of 16 who had far more IQ, or whatever that is, men of 50.
Yes.
Some men of 50.
That's what I've argued here, Judge. And you immediately see the Pandora's box that is being opened here, and when you realize that the objectives of this law can never really be attained. I argued in my brief that these objectives are not attained because the younger children could get them from older. They can always find them around. Secondly, what is even worse, in order to prosecute anybody, you'd have to do what you did in this case, and that is involve the youngsters in the criminal court. The youngster in this case was acted as a decoy in a case that was specially framed for the purposes of enforcing this law. And of all the most remarkable things that I know of, that in an amicus brief in this case, in opposition to my position, the Citizens for Decent Literature took the very same position, that this law cannot be enforced, and it's worse than if there were no such law, because the debasement of the child is a factor that is worse than the literature that they could read. I have a great deal more to argue, but my time is up, Your Honor. I'll have to rely upon my brief.
May I ask you one, returning to your first argument, what page did you say it could be found on that the judge relied not merely on the pictures of nudity, but on the literature that was written?
Yes,
248.
248, the last paragraph on the bottom of that page.
All right, thank you.
Mr. Kahn?
Mr. Chief Justice, may it please the court.
What about this Colon, Arkansas point?
Which is that,
That he was convicted on something of which he wasn't charged.
I don't believe that's quite correct, sir, because...
Well, that's important. I mean,
the
if that was so, this couldn't stand, I take it, could it?
I would agree, Mr. Justice Brennan. The information specifically charges in the second count.
Page 4? What language charges the written
Language
material?
which suggests harmful to minors, and which, taken as a whole, is harmful to minors.
Now that incorporates the written as well as
the pictorial part of the
why do you
magazine.
say that?
Because the entire statute gives reference, Mr. Justice Brennan, in its description of what is obscene.
Right.
That's the statute, but the charge doesn't.
The charge mentions in the second count, the defendant did violate the provisions of the said section 484H, subdivision 2B of the penal law, in that the defendant did knowingly sell to a minor a magazine which, and taken as a whole, is harmful to minors. And I submit, Your Honors, that this applies to the written as well as to the pictorial part of the magazine. I believe that the major issue on this appeal is whether a state may, consistent with the due process clause of the 14th Amendment, enact a law founded upon the variable obscenity concept, prohibiting the commercial distribution to children under 17 years of age of materials obscene as to such children, although not necessarily obscene as to adults, and whether the statute in question, section 484H of the penal law of the state of New York, is a valid children's obscenity law, whether its phraseology is sufficiently definite.
Mr. Kahn?
Yes, sir.
How is it that New York has 17 and Dallas has 16?
This is a matter for the legislature, Mr. Justice
Out
Marshall,
of the
and...
clear blue?
Pardon?
Out of the clear blue?
Well, the legislature found it in its wisdom that the obscenity statute in reference to 484H should apply to those under 17 in perhaps for different reasons, and the state of Texas found it should apply to those under 16 for the reason that the states have considered 21 to be the age for qualified voting rather than 15, 16, 17, or 18. I have no definite reason to give you as to why the state legislature saw fit to limit its exercise over children to the age of 17 rather than 16 or to 18 or to 19 or any other age for that matter. And if I may continue, the question is whether or not the statute's phraseology is sufficiently definite to satisfy the minimum requirements of due process as they relate to obscenity, and whether its scienter clause is objectionable or exerting an undue restraint on commercial distribution to adults of materials within the prohibition of 484H. 484H, a violation of which was punishable as a misdemeanor, is a children's obscenity law validly based on the variable obscenity concept approved by this court in Michigan against New York. It was characterized as a children's obscenity law by New York's highest court, the Court of Appeals, in the bookcase incorporated against Broderick case. And this court, of course, held in Michigan that it will accept such a characterization. I submit that the Court of Appeals characterization is correct, since the statute's definition of harmful to minors includes the elements of this court's definition of obscenity, that is, predominant appeal to prurient interest, patent offensiveness, and absence of social importance, with slight adjustments of wording necessary to relate and confine its prohibiting reach to children.
Well, now, Mr. Kahn, that being those being terms of the statute.
Yes, sir.
I've just looked at these magazines. I think you'd agree, limiting this now to the pictures for the moment, that magazines precisely like these, in the context of obscenity determinations of distribution to adults, have been held by this court in a number of cases now to be not obscene.
There's no question about it.
So you've got to say that although in their distribution to adults they are not obscene, nevertheless we should fashion a principle that in their distribution to children under 17 they are obscene. Is that it?
Even though it is not obscene as to adults, and adults in this particular statute are not bound by the rigid concepts established by the statute. The Court of Appeals decided in the Broderick case, rightly it is submitted, that children were a recipient group within the Michigan Doctrine because they are the group to whom the objectionable material is directed or from whom it's quarantined. The Court may judicially notice, I submit, that these materials, including girly magazines, are directed to children.
No, why do you say that?
Because experience has taught us, Mr. Justice Fortas, that the teenager is the greatest market for these girly magazines.
Is that in the record?
It is submitted and suggested by the appellee's brief.
Well, it's not. Is there anything in the record? Because that surprises me.
No, there is not, sir.
I have limited experience. I would not take judicial notice of that fact. Is that what you're suggesting?
Well, I am suggesting that because of my own experience, Your Honor. I have found that...
These stories, is the written material in here on the level of what we commonly think of as boys? Of course, when I was young, it was the algebra boys and things like that.
Times have changed since then.
Times have
Justice
changed.
Fortas.
But is that so? Is the written material of the what is specifically and especially a youthful kind?
The magazines to which we refer, the magazines in question, are written, in so far as my own personal opinion is concerned, with a direction toward the teenage market, and not very bright teenagers at that.
And what?
And not very bright teenagers at that.
Well, to me, this is an important point, but I don't know that I'm at liberty to take your judgment for it in the absence of anything in the record. That is, I know of nothing, so far as I have gone through the record here, that would indicate that these magazines were especially prepared or specially directed for that segment of the population which is included in this statute.
I might agree, Mr. Justice Fortas, but as I said, it has appeared from the experience which I have had with dealers...
You might agree or you might not, but there's nothing in the record.
Nothing in the record. There's no question about it. Now, I think that the Michigan case holds that it will accept the characterization as placed upon the statute by the Court of Appeals, and I have already mentioned the basis of the Court of Appeals characterization. In the Michigan and Ginsburg cases, I think, very frankly, that the Court has noticed the prurient interest of these so-called girly magazines. And in Michigan, no psychiatric testimony or the like was presented to show that the material in question appealed to the prurient interest of sadomasochists. However, 484H could have exercised its regulatory effect constitutionally, even if it were not an obscenity law, and thus the question of whether the state's proof in this case satisfied the obscenity criteria of 484H is not a federal question, eligible for decision by this court. Since the people's proof shows beyond a reasonable doubt sale with the requisite scienter of nude photo magazines to a 16-year-old boy, it has proved all that need be proved to justify criminal punishment on constitutional grounds, where the attribute of sovereignty on which the prosecution and statute is founded is the state's power as parens patriae for the benefit of children. Since 484H is an obscenity law, I don't believe the appellant can raise the First Amendment objections to it, since under this court's holding in the Roth against the United States case, obscenity is not protected expression. The scienter provision knowingly is not invalid on its face because it will not restrict by indirect effect the flow of protected material to adults within the rationale of Smith against California. This is so because most adults are patently over the age limit set out in 484H, under 17 years of age. Thus, dealers will not withhold sale to adults and will not fail to make a sale where the adult is a customer. Moreover, the law provides for the defense of honest mistake as to age. It follows that the dealer who has made inquiry as to age and received reassurance will rely on the honest mistake provision and will not hesitate to sell to an adult at all, even if the dealer has not examined the work in question. In the few situations where age is in doubt, the buyer to whom allegedly the dealer might be hesitant to sell in the absence of an honest mistake provision as to age will usually not be an adult, but instead will be a youngster. Indeed, most youngsters in this marginal age group are so young that they have been included in they could have been included in 484H's prohibition without giving constitutional offense. Thus, indirect restriction on distribution to them does not raise federal questions. Since they could be denied access by direct prohibition, it's constitutionally indifferent whether the state has instead contrived this acceptable denial of access by indirect means. There is nothing constitutionally objectionable in placing the burden of judgment on the book dealer and to require him to determine if material sold by him comes within the prohibited class. In Michigan, this court approved a New York statute, namely Section 1144 of the Penal Law, the old section, 1141, which it viewed as placing the same burden of judgment on book dealers as on publishers. Appellant's claim in this regard is a vagueness argument in disguise, but this court, in effect, has held that the definitions of obscenity in Roth against United States, Manual Enterprises against Day, Jacobellis against Ohio, and the Michigan, Ginsburg, and Fannie Hill cases are adequate. It follows that the definitions in 484H give sufficiently definite notice of what materials are within its prohibition and do not place an excessive burden on the dealer.
I don't understand you, sir, because you thought you agreed in response to questions by Mr. Justice Brennan that these magazines would not be held obscene and therefore outside of the First Amendment protections in the case of an adult. So what comfort do you get out of Roth and all the rest of them? You've got to go beyond that, don't you, to take care of this particular case and say that two things are outside of the protection of the First Amendment. Number one, the Roth type of thing, as embellished by subsequent cases. And number two, something that is less than Roth in the case of children. Don't you have to take that position?
No, Mr. Justice Fortas, I agree that these magazines, if sold to adults, would not constitute a violation of any obscenity statute. However, taking these magazines insofar as children are concerned, I submit that they are obscene, that they have been held obscene by our state's highest court in accordance with definitions set forth in Roth and the other cases, with changes in phraseology limiting its application to children.
Your state courts might have held that over and over again. But on the basis of the colloquy between you and Mr. Justice Brennan, this court would have to say that these particular magazines here are within the protection of the First Amendment. If you relied only on Roth and our decisions to date. Now, what you're asking us to do, and perhaps you have to ask us to do it, is to come out with another category restricted to statutes dealing with children.
Well, this is the variable concept doctrine, is it not?
Be straightened out on it.
I believe that this is the variable concept doctrine, Mr. Justice Fortas. I may be mistaken, but I believe this concept definitely applies in this particular situation.
What would you add to the Roth definition, or subtract from the Roth definition, in the case of children? Or why do you say that these magazines, although by hypothesis would not be held obscene in the case of adults, should be held to be within the First Amendment, should be held to be outside of the First Amendment protection in the case of children?
Because taken as a whole, these magazines are harmful to minors, as our statute specifically states. That the magazines in question, these magazines, although not obscene to insofar as adults are concerned, when taken into consideration in the juvenile area, are harmful to minors.
And we have to sustain that as being sufficiently precise and not too broad or too vague for First Amendment purposes.
Yes, because harmful, the terms in the statute are very explicitly explained. Each and every term used: nudity, sexual conduct, sexual excitement, sadomasochistic abuse, harmful to minors, and prurient interest, and so forth. Each and every item to which the statute refers is clearly defined by the statute. And the changes to which I refer, making the overall magazine harmful to minors, is that which I ask this court to take into consideration to accept.
May I ask you if your court has ever sustained this particular charge made in count 2 to the extent of saying that it charged anything more than the fact these were bad because they had pictures of nude persons?
Mr. Justice Black, I can't honestly answer the question. I don't know.
As I read it, I draw a different inference to yours. It seems to me that what they're saying, that taken as a whole, these pictures of nude persons are harmful to minors.
The magazine taken as a whole.
Well, I don't find that.
Oh, I see, sir.
I haven't been able to find that yet. Seems to me like it means the other.
I would have to
That's the reason I asked
respectfully
if your
disagree.
court had ever construed it the other way.
Well, I gather that under this, as I read the statute, nudity alone is not proscribed. I gather that it's only nudity which is harmful to minors.
True.
And nudity which is harmful to minors has to be patently offensive.
Patently offensive.
To prevailing standards in the adult community as a whole with respect to what is suitable material for minors.
That is correct.
And is utterly without redeeming social importance
that is
for minors.
correct, sir. And so, under this particular statute, great works of art would not be involved. The nudity in the magazine must appeal to prurient interest, must be without social importance.
Any picture, any nude picture in a magazine would be bad under the statute?
No, sir, not any nude picture. These magazines, which contain pictures of nudes, we contend, we proved, were directed to the prurient interests, were without social value, were provocative, were for the purpose of sexually stimulating.
Have you got one in particular you could show us? I've looked at all of them. You got in one page you could suggest that nude is different from the other nude?
I don't have the magazine with me at this time, Mr. Justice Marshall.
Mr. Mr. Redfield had one there, or some, I guess.
The one in
there.
question?
I've all the four in question. Could have one.
Go ahead, you got one?
I submit that all of these pictures, as they are for the purpose of sexual stimulation rather than for purposes of displaying great works of art, are
Then you say all nudes.
all of these nudes in their positions, in their
What?
provocative positions,
I don't say any different from those nudes and all other nudes we've had coming through here.
insofar as children are concerned, Mr. Justice Marshall?
We didn't look at them, the others are for children.
Well, this is
Well,
why
I'm just trying to say, aren't you actually saying that nude in and of itself is bad?
That's
For children.
That's really, I really wonder if the statute wouldn't reach all nudity, any kind of a nude in that magazine.
I respectfully must disagree with the...
Well, let me ask you, what about the nudist magazines, which have been held not obscene for adults? How do you think they would fare under...
Mr. Justice White, I have enough of a problem to cope with that which I have rather than to become a prophet, and I don't know.
Thank you.
This is entirely up to the courts to decide.
Well, I must say, Mr. Kahn, I don't know why you say that any picture, in light of 2A, incidentally, this prosecution's under the 65 statute, of course, not under the amended 67 statute.
That's correct, sir.
Now, as I read at page 29, I'm looking at Mr. Redfield's brief. The statute, unlawful for any person knowingly to sell or loan for monetary consideration to a minor any picture, skip the rest of it, or any photograph which depicts nudity and which is harmful to minors.
And then harmful to minors is defined, though.
And the harmful to minors is very vividly described in subdivision F.
Yes. It has to have all of the Roth elements.
That's correct, sir.
But any single picture, it would seem to me, looking at A, that satisfied that description in this magazine, even if none of the others did, would support a prosecution under A, wouldn't it? If there were a single
Yes.
picture.
If it violated
That's right. If it was harmful to minors, with
Yes, I would say so.
No, so that the as taken as a whole is meaningless, isn't it?
Well, that's in subdivision.
Well, I know, but this gets me. That's why I'm troubled by the Colon, Arkansas point. I must say I have difficulty reading count 2 as drawing in what apparently the trial judge relied on, namely the written materials.
Well, I don't think he relied on that. I think he added that insofar as his judgment was concerned, and I think he had absolutely every right to do so under the...
You say that what he did is merely surplusage, that on the...
No question about it. Because he found violation of paragraph A as well as paragraph B. And with the limited time left, may I discuss...
Could I just ask you,
Yes,
before
sir.
you go on, just under the New York practice, and under a suspended sentence, may the defendant be called back into court and sentenced later, or is that the end of the matter?
If it's a straight suspended sentence, it's over. The sentence is finished. Yes, sir. If provisions and limitations are set forth as under the suspended sentence...
But when he doesn't impose a sentence and then suspend
That's
it,
correct, sir.
but just suspends
Straight
any sentencing, the case is over.
That's
So
correct.
there is such a thing then as a final judgment suspending sentence.
That's correct.
I see, and that's what we have here.
Yes, sir.
Well, does that have any consequence at all?
I don't see where it has.
I mean, it's just like it's sort of a reprimand. Is that what you're telling us?
No, I'm telling you that this was the punishment meted out by the court. He found it in his wisdom to give the defendant a straight suspended sentence.
And what's a straight suspended sentence?
Just
Does
that,
that mean
sir.
that he can ever be put in jail for this offense?
No.
Can he ever be fined for this
No.
offense?
No, sir.
So it's sort of a reprimand, is it?
Well, it's...
Well, why isn't this, a year or so ago, we dismissed a couple of cases here where in a New York prosecution where a man had been fine, but he had paid his fine. We dismissed the cases as moot. Wouldn't these be moot a fortiori under that?
My distinguished colleague has called for determination of the constitutionality of the
Well, I
statute.
know, but that doesn't require us to give it if the case is
I
moot.
understand. Whether the question is moot, I certainly submit as for this court to decide.
What do you think?
Well, I think we've come a long way for...
You like it. Everyone who comes here wants us to pass on some constitutional question, doesn't he?
I will say
Whether
this.
we have to or not.
May I say this in due respect? Suspended sentence or no, this is a conviction of a misdemeanor, of a crime, on this man's record. And if by judgment of this court it is erased, I think it is to his benefit.
Well, but if, then you're suggesting we were wrong a couple of terms ago when we dismissed these misdemeanor convictions where the fine had been paid. And there were no civil disabilities or anything else that's
Perhaps,
justified.
maybe, Mr. Justice White, this may be characterized as a more serious offense since it involves possibly moral turpitude. And,
That's what they were. They were
well, I don't
obscenity
know that-
convictions.
They were obscenity?
obscenity convictions, and fine had been paid, and we dismissed the cases as moot.
Well, certainly, let me say this for myself. If I had a misdemeanor conviction upon my record and I had the opportunity to have it erased, I would seek every available pathway toward that end.
That doesn't answer whether or not those other cases are not precedents for dismissing this as moot.
I can't talk without seeing the cases themselves, Mr. Justice Brennan. I ask you to forgive me because I just don't know the
It would be a
cases
different
to which we're
proposition, I suppose, if these sentences could be imposed. But if this
There is no
case is
sentence to
over.
be imposed, Mr. Justice White. The case, insofar as punishment is concerned, is completely over. And may I conclude by stating that it is perhaps impossible to determine or measure cause in the realm of social affairs. It is especially difficult to determine with certainty whether exposure to certain types of influences gradually shapes character or morals in given ways, since such shaping force works unobtrusively and does not manifest itself in dramatic incidents of cause and effect. Thus, persons who demand certain scientific proof may be asking the impossible. Constitutional adjudication must be content with a lower order of demonstration, or the community will be rendered helpless to protect itself against influences which common knowledge and much expert opinion brands as dangerous. It should not be made to run the risk or to gear itself to the uncertain rhythms of scientific progress. The greatest social thinker of our time, Robert McIver, has observed that knowledge in the social sciences will always be incomplete and imperfect. I submit that the danger of these magazines insofar as juveniles are concerned has clearly been established and should be banned.
In this record,
Yes.
it's been established in this record.
The danger itself, sir?
Yes.
No, sir, in the cases that have gone heretofore.
Ms. Redfield.
I have a few minutes. As to the question of mootness, Your Honors, on the very day that you dismissed those other cases, one was the Tannenbaum case, and I forget the name of the other one. This case was granted review, and the year had not passed under New York law in which there could be execution under that sentence. So, while I'm not
Yes,
prepared
but
to argue that case now,
I gathered from the state's presentation that once that sentence was suspended, that was the end of the case, and then no sentence could be imposed.
No, I wouldn't go along with that because it's the very same statute you had in the Tannenbaum case and in the other case.
Yes, but there they
within
paid
the
the
year.
They paid the fine in Tannenbaum.
Well, but
They were only fined in those
yes,
cases.
yes. Right. But that wasn't the gist of the decision. The gist was that there could still have been execution within the year's time. And while perhaps at this moment, I don't know, I'd have to study the point. While at this moment the year might have passed, at the time you granted review, certainly at the time when this case was lodged in this court, the year had not passed.
Well, Mr. Redfield, I understand the counsel for the state to say that if he merely says suspended sentence without any particular sentence that he suspended, that the case is ended then and there.
No, I wouldn't.
And you say the opposite.
I wouldn't accept that.
All right. Now, could you both give us a brief memorandum of the thing in the next day, 2 or 3 days?
You really have it in the other cases because the law is set forth.
I know, but if it's simple,
I'll be happy
will you
to.
give us a memorandum,
Yes.
please? Both very much.
Would you state now why you think it doesn't end? What else to be done to it?
What else is to be done?
What else could be done?
Well, it isn't.
No, that's right.
Well, at this moment, I'm not prepared to say that, Your Honor, because this is a point I haven't even examined. All I know is this man has this conviction against him, and under New York law, a second conviction would result in more serious punishment to him.
Well, that's a different thing.
Yes. But aside
Well,
from...
would you cover that? Are you sure? I'd be interested in
Oh, yes,
whatever you're going to submit.
you have it
No, I'm
repeated.
interested in whatever you're going to submit, what the consequences of this may be.
Yes.
If it's a conviction for the purposes of an enhanced punishment on a second conviction, that, at least to me, would be quite important.
You have that in
Well,
the
will you
other
cover
case.
it in your memorandum, Mr. Kahn, shaking his head vigorously that isn't so?
Well, if you look at the record, let's say in the Michigan case, for example, you had that situation where a second conviction led to a higher sentence. Michigan had been convicted once before the case he was in here for, and it
Was
resulted...
he here on a misdemeanor?
He was here on a misdemeanor,
it may
and
be
he got
different.
3 years. Pardon?
It may be different if a judge uses it in connection with sentences, with sentencing. That may be different from the law requiring a higher sentence
Well, the
because
law...
of the prior conviction.
You mean whether it's compulsory or whether it's discretionary with the judge? Is that what you mean? Yeah,
Well, whatever your state law is, I at least would be interested.
Yes, I'll be happy to present that. But before I terminate, I'd like to point out something of substantive interest, and that is the reliance here upon Michigan. I don't think this case has been disposed of by Michigan. First of all, in Michigan, you had a deviant class, and it was not one of age. In Michigan, you had the books. The court found that the books were directed toward this group, and they were pure appeal to that particular group. Here you have an entirely different question of age, and Your Honor was very careful to point out to avoid Hicklin being revived by saying the following: since our holding requires that the recipient group be defined with more specificity than in terms of sexually immature persons, it also avoids the inadequacy of the most susceptible person facet of the Hicklin rule. Thank you.